SCOTUS RUCKUS. Produced by InlexVeritas.com.
This is Lexi Totberg, a reporter for SCOTUS RUCKUS. Thank you for tuning in. SCOTUS RUCKUS is a program dedicated to giving our viewers an in-depth look into the cases pending in the Supreme Court of the United States, through the lenses of the oral arguments. As always, with me, is our legal analyst, Dave Weinstein.
Thank you, Lexi.
This is a special edition, which focuses on the case, Spokeo, Incorporated versus Robbins, which was decided on May 16, 2016. For the details of this case, please refer to other past series of SCOTUS RUCKUS. Dave, can you break down this case for us? The decision came down rather fast, it seems.
Yes. You're right. The Supreme Court vacated the Ninth Circuit's judgment and remanded the case to the lower court for further proceedings. Justice Alito delivered the opinion of the court, in which Chief Justice Roberts, Justices Kennedy, Thomas, Breyer and Kagan joined. Justice Thomas filed a concurring opinion. Justice Ginsburg filed a dissenting opinion, in which Justice Sotomayor joined.
So, it was a 6-2 decision in favor of Spokeo.
Yes, although the court sort of punted the case to the lower court, without deciding on the substantive legal issues. It is as if the court had said that the case has not yet ripened to be decided on, at this early phase of the case at its pleading stage, without a fully developed factual foundation. As is the usual pattern, the so-called conservative bloc, which includes Chief Justice Roberts, Justices Alito and Thomas, was in the majority. This is a guesstimate on my part, but while the liberal to center-leaning bloc of justices, which includes Justices Kennedy, Breyer, and Kagan, probably wanted to side with the respondent plaintiff, Thomas Robbins, but the determinative facts of the case seemed unclear at this early stage, and so for practical reasons, I suppose, the three justices probably joined the majority to remand the case for factual clarification at the lower court. On the other hand, I think Justices Ginsburg and Sotomayor in a commonsensical way saw enough facts to support standing even at this early stage of the case, and filed a dissenting opinion.
Now, we have, for our viewers, a dramatized explainer skit, which portrays the punchlines of the Supreme Court's opinion in a lampoon sort of way. Let's watch.
This is a story of one Thomas Robbins, and his journey to find elusive standing, to have his day in court.
Please identify yourself and state the purpose of your presence.
This is Thomas Robbins. I'm here to see the judge.
Checking the docket schedule database. Confirmed. Docket number 13 to 1339. Case name, Spokeo, Incorporated versus Thomas Robbins. Please enter. Hold. One Thomas Robbins, respondent, plaintiff at the district court. In order to proceed, to have standing before the court, there has to be an injury in fact, de facto injury, actual or imminent, or tangible harm that is concrete and particularized and actual or imminent. Is there such injury or harm?
Your Honor, didn't quite understand them lawyering talk with them fancy words. They sound basically the same to me. But I did pick up a few words, like the word injury. Your Honor, I do not have injury to my body or to my sound mind for that matter. I mean, it's not like someone stabbed me or anything. I also heard this word harm. If Your Honor is talking about the money, I've not been harmed like in Payday loan sharks have harmed me.
Processing. You are not deemed to have an injury in fact for the purposes of the court's general standing requirements. Please proceed to the contemplation chamber to your left, and stand by.
Damn. Did I say something wrong? What did that lawyer told me to say?
Halt. You failed under the general injury in fact or tangible harm test for standing. However, you may still have standing under certain circumstances. Please answer the following questions. First, is any of your property right involved in this case?
Your Honor, I'm not well off as a Spokeo.com says I am. I rent the place I'm at, and I probably owe more than I own. I didn't quite get what Your Honor is getting at, but I don't think so.
The answer is unresponsive. Processing. The property right is deemed not to be involved in this case. Second question. Were you defamed by Spokeo.com?
Well, I'm not a famous person, you know. I'm just a regular guy on the street, looking for work. I ain't sure what defame means here, but it wasn't dissing, per se. But that Spokeo.com sure says some wrong things about me.
The answer is unresponsive. Processing. Defamation is deemed not to be involved in this case. The standing may be found in the property right or defamation-like cases, but since neither is involved here, in your particular circumstances, at this stage of the proceedings, there has to be a showing of a concrete and particularized injury. Examining the facts of your case, there is an uncertainty as to concreteness, and the case is remanded to the lower court in the Ninth Circuit. Goodbye. End processing.
But Your Honor, Spokeo wronged me, and the people like me.
The judgment of the Court of Appeals is vacated, and the case is remanded for proceedings consistent with this opinion. It is so ordered.
This was interesting. I know you had some inputs into producing this explainer skit. Any comments or anything you want to add?
Well, the judgment is a bit odd in that it doesn't seem to move the needle in any direction in terms of legal precedents. It just seems to partially regurgitate the principles already set down in Lujan case. The majority opinion, after restating that the irreducible constitutional minimum for standing is injury in fact, narrows in on the requirement of concrete and particularized injury. The majority opinion was of the opinion that the Ninth Circuit in effect ignored the concrete portion of the requirement and remanded the case to the lower court for further proceedings. Had the Ninth Courts contained one more sentence about concreteness, the majority opinion would not have had a leg to stand on. I'm sorry for a tacky pun. The majority opinion seems to artificially add another layer of definition to the injury in fact requirement for standing. I mean, if there is some form of injury, tangible or intangible, the logical inference would be that it is a concrete injury. Also, the majority opinion is somewhat short in length and choppy, which suggests there was a lot of negotiated editorial clippings to produce a final draft, to which liberal justices like Kagan and Breyer could join. Justice Thomas wrote a concurring opinion, which went into a tangential narrative about the public and private rights.
So, what would happen to the case now?
Well, it would be remanded to the lower court and the Ninth Circuit for further proceedings, which basically would be a do-over or relitigation. But, this assumes that the plaintiff side is willing to put more resources into this endeavor. Remember, This case makes sense economically only if the class action could be established. An individual case is worth only $1,000 at most from the plaintiff's perspective, which no lawyer would take on an individual case basis, considering the costs and legal fees, and so forth. I mean, I'm assuming that the suit with the plaintiff-respondent, Thomas Robbins, has been 100% financed by the plaintiff lawyers. I mean, Thomas Robbins, being unemployed and all.
Dave. Thank you for that insight. We will certainly keep an eye on this case. For now, we will take a break here, but please tune in for the next installment of SCOTUS Ruckus. Bye-bye.